Welcome everyone to the first videos of our YouTube series. In this video, we aim to help you understand the basic of public international law. We also aim to help the new Mooters to understand and get more substantive knowledge. Also, there will be mooting approach integrated here and there, so you can understand both substantive and also the tips for the moot court competitions. So the topic that I'm responsible for today is the basic of public international law, specifically in the sources of the PIL. So before I begin, I'd like to introduce myself a little bit. My name is Woraissara Nuvong, and my nickname is Mind. You can call me Mind. I recently just graduated from University, and I previously competed in the Philip C. Jessa for Thammasat Team 2025. I also competed in a cross moot between Thammasat and Jula called IMAC X TIMS for 2024. So without further ado, we will begin on the background of what is the public international law. I think everyone might be more familiar to the concept of the national law. So I will give you a comparison approach between the public international law and the national law. So in the national law, you might have heard a saying, almost cliche, and if you're a law student, you definitely have heard of it, that if there's a society, there's a law, because you have to be able to regulate and keep peace in the society. So in the national law, the people in the society are the citizens of the country. So for example, if you're in Thailand, you're Thai national, you are under Thai law. It could be the criminal law or a civil and commercial law. And the subjects of the law could be a national person, a legal identities that registered in Thailand, depending on the law. But the thing is, you cannot pick and choose whether you will be obliged by the law or not. If you committed a crime in Thailand, for example, if you kill someone, you cannot choose that you will not be bound by the punishment because you are under the power of the states, and the state have its own sovereign power. That's how it is in the national law. But in countries, in international communities, the member of the communities are states. For example, it could be USA, Thailand, China. And according to the international law, every state in the world are equal because all the states have its own sovereign power. So therefore, the states will have obligations under international law only if it consents to. So you cannot force any states to subject themselves to any obligations if they do not want to. And that is the foundations of the international law. It's based on the principle of the consent of the states, and also this is the principle of decentralization, because we doesn't want any states to, sorry, let me move the slides. This is based on the principle of consent and also based on the principle of decentralization, because we don't want any states to have power in other states. So after, I think you might understand a little bit of the background. So let's proceed to the slides. What are the definitions of the public international law? So simply saying it is a set of rules or principles. We can also call it precepts that regulates how certain actors interact. So the actors in this context are mainly states, because we are talking about the international communities, right? And to some extent, it could be organizations, international organizations, or individuals that's subject to international law. An act of compliant or non-compliant of the states to those precepts involves certain consequences. So for example, if the states consent to an obligations to comply with it or not to comply with it, that's called the state responsibilities. So the actor states may choose to comply or not to comply with, as I have mentioned before, that they have the discretions and they have to keep consents. So why there is the International Court of Justice, also as we know, we call it ICJ, and a range of specialized international tribunals. Their jurisdictions is critically dependent upon the consent of states, and they lack what can properly be, my apologies, properly be described as a compulsory jurisdictions of the kind processed by national courts. So what do I mean by that? In the context of national law, for example, you committed a crime, as I have given this example before, you are Thai, you committed a criminal offense to a Thai person in Thailand. You have to go to Thailand court. Even though you don't trust Thai court, you have no choice to go to any other court because you are under the sovereign power of Thailand. And that's left you no choice but to go to the court in Thailand. But in the international communities, as I said, the principle of consent is the backbone. So therefore, any state cannot force you as a state to subject yourself under the power of the International Court of Justice. Let me give you an example that everyone might be familiar to. Thailand and Cambodia have been having this disputes on the territories for a long time. And as you see, we have a problem with the previous year case that is a very famous case that Thailand and Cambodia went to the International Court of Justice, and the court is not ruled in Thailand's favor. So therefore, recently, this is what published on the Ministry of Foreign Affairs of Kingdom of Thailand. It's the Thailand positions in response to Cambodia's submissions on 15 June of a letter to the International Court of Justice related to Emerald Triangle, Tamanton, temple, blah, blah, blah. But the context is that Thailand has stated that Thailand has not accepted the compulsory jurisdictions of the International Court of Justice since 1960. And this is a position that 118 other member states of the United Nations have also been taken. So as you can see that Thailand and 118 states also does not accept the power of ICJ, and that is very doable in the international law. So the result is that international law is made largely on a decentralization basis by the actions of the state which make up the international communities. So after you get a grip of the international law background, so let's move on to our main topic today. What exactly is the law? What are the sources of international law? The answer is, you can look into Article 38(1) of the ICJ statutes. So let's see this article together line by line. So according to the paragraph 1, the court whose function is to decide in accordance with international law such disputes as are submitted to it shall apply. So this means that this article outlined that the court can take in consideration the subparagraph in this Article 38 as the material that they will take in considerations. Therefore, naturally, the court and the state has accepted these articles as the authoritative sources of international law. So as you can see here, there are 4 subparagraphs. Article 1A, Article 1B, Article 1C, and Article 1D. If you look into it, you will see the bold blue text saying subsidiary mean. So I will just let you know firsthand that Article 38 1D is subsidiary mean, meaning that it has a secondary nature. And you may ask whether paragraph 1 create a hierarchy of sources between the rest, which means like paragraph A, B, and C. The answer is there's actually no hierarchy between them. However, in practice, subparagraph A and B are the most important, we can explain that the priorities of paragraph A by the fact that it's referred to a sort of obligation which will ordinarily prevail in being more specific. I mean, you might not get this for now because we haven't dived into each paragraph by paragraph, but I will explain you later why A is, in practice, is mostly ordinarily prevail. So let's look into subparagraph by subparagraph. So A, the first source of the international law is the International Convention, whether general or particular, establishing rules expressly recognized by the contesting states. The contesting states here are the disputing parties that bring the case to the court. So the party that are disputing must be the party of that international convention. I'll explain more later because we will be moving on to each paragraph by paragraph specifically. And subparagraph B, international custom as evidence of a general practice accepted as law. So to give a comparison to Thai law, so you can understand better, this is pretty much similar to กฎหมายจารีตประเพณี Not exactly the same, but that's the idea. And C, the general principle of law recognized by the civilized nation. The closest comparison to Thai law could be หลักกฎหมายทั่วไป. And D, subject to the provisions of Article 59, judicial decisions and the teachings of the most highly qualified publicists of various nations. So the sources here are subsidiary mean, and it's divided into two things. So first of all, the judicial decisions, so the past rulings of the court, and second, the teaching of the most highly qualified publicists. So how is this useful for the moot court competitions? So in the moot court competition, right, you have to present to the court that the opposing party acts against or the action is not aligned with the obligations arising under the international law. Or you have to prove that your actions is aligned with the international law already. And while you are presenting your argument, the judges may ask you about the material you claim as evidence of existing international law. The court might also ask you why the court should take this material that you are presenting to the court into considerations. Then it is the time for you to refer to the subparagraph in Article 38. To put it simply, you should be able to recall this subparagraph in Article 38 and be able to distinguish between them of what your material, or which subparagraph your material fall into, and understand the weight and the hierarchy between these subparagraphs as well. And I would like you to know a little bit, since we have mentions on the principle of consent that is the backbone of the international law. Subparagraph A, B, and C also clearly reflects that. After I have already shown you Article 38, and you have seen the subparagraph, which are the sources of international law already. So now we will zoom in and talk about the subparagraph by subparagraph. So first, let's look into Article 38, 1A, International Convention establishing rules expressly recognized by the contesting states. In Thai, we call it สนธิสัญญา อนุสัญญากฎปะพิธีสารบันทึกความตกลงนะคะ So let's look at the definition of it. We can find the definitions of the International Convention, aka treaty, that we call in the Article 2.1a of the Vienna Convention on the Law of Treaty, which from now on I will be referring it as VCLT, so it's shorter, right? So treaties means an international agreement concluded between states in written form and governed by international law, whether embodied in a single instrument or in two or more related instruments, and whatever its particular designations. So the treaty is an international agreement that can be bilateral, which means between two states, or multilaterals, which means it is concluded between more than two states, and it can be in single instruments or in two or more related instruments. So in the moot court competitions, what should we look into to see that your opposing party is bound by the treaty and have responsible and obligations under that treaty? So first of all, to check whether a particular provisions of a treaty is enforced between a particular pair of states, we must check that the states has signed and ratified the treaty and did not reserve the provisions. So you have to check with the statement of facts in the moot court competitions. It should be clearly stated that your party or opposing party, according to your argument that you want to make, has signed and ratified. And the second thing that this slide mentioned, did not reserve the provisions. So what does it mean by reservations? So the reservation here, we can also call it Customary in Thai. It is a unilateral statement made by a state when signing, agreeing, or ratifying a multilateral treaties. That states reserve the right to not be obliged by the treaty as a whole. So the state doesn't want to be bound by the treaty's text as a whole. So the states can make a reservations by excluding or modifying the legal effects on the specific terms of that treaties. Simply saying that the state does not consent itself to be bound by the treaty as a whole. So after you have checked that, okay, your party or your opposing party has signed and ratified the treaties, check whether they have made the reservations on that part of the treaties, then in the moot court competitions you can present to the court that your parties or your opposing party have the obligations under this certain treaty. In the international convention, it has to be aligned with the Latin phrase called Pacta sunt servanda. So in Thai, we call it Sanya, Pacta Sanya, which means every treaty enforced is binding upon the parties to it and must be performed by them in good faith. And let me give you an example from the North Sea Continental Shelf case. This ICJ did not accept the argument of Denmark and the Netherlands that Germany, which has signed but not ratified in the 1958 Geneva Conventions on the Continental Shelf, blah, blah, blah. So the court really take considerations that the party must sign and ratify the treaties. So what if the states have signed but not ratified, or they haven't even signed and ratified the whole treaty things? What could be the consequence of that? So naturally, it's not applicable under Article 38(1)(a), which means that in the moot court competitions, you cannot make an argument that the states does not act in accordance with the first clause of international law, Article 38(1)(a), or they do not have the obligations under treaties. You have to make other arguments in accordance with other sources of international law instead. But I would like to note that many treaties are also important as authoritative statement of customary international law. So if you remember, it is the second source of international law in the Article 38(1)(b). So a treaty which is freely negotiated between a large number of the states, often regarded as written down or previously unwritten rule. So to refresh your memory, customary international law ถ้าเปรียบเทียบกับไทยมันคือกฎหมายจารีตประเพณี So it should be the general practice that's accepted as law. I will dive deep down into it later, but what this is trying to say that the treaties, if it's freely or widely negotiated, it could be a reflection of the practice and which could give rise to the customary international law. So a good example of this is the Vienna Conventions on the Law of Treaties. Every court which has considered the matter has treated its main provisions as codifying customary international law. So this means that even though the states are not the party of the Vienna Conventions on the Law of Treaties, since the court has treated some provisions as the customary international law. So you can make an argument that that state does not act in accordance with the customary international law, or you can bring up the Vienna Conventions on the Law of Treaties as customary international law. So we finished with the first subparagraph of Article 38. So let's move on to the second subparagraph of Article 38. Article 38(1)(b), International Custom, or we call it Customary International Law, or CIL. So what are the elements of it? What gives rise to customary international law? So you have to check with the two main aspects. So first, it is general practice. It's referred to the practice of the state. It can be practice of the international organizations also that contributes to the formations or the expressions of rule of customary international law. State practice consists of the conduct of the state, whether it is in the exercise of executive, legislative, judicial, or other functions. So first of all, you have to check if there's a practice. The second element is those practice must be accepted as law. You might have heard of the Latin phrase opinio juris, meaning that the practice in questions must be undertaken with a sense of legal rights or obligations. And the ILC have explained that opinio juris is not to be distinguished from a mere usage or just habit. So it should just not be the habit of the state, but the state practice it because the state feel like there's legal responsibilities to do it. So let's look more into the clarifications of the general practice or the opinio juris aspect. So according to the conclusion 8 of the ILC draft conclusions on identification of customary international law 2018, which is a very good source if you don't understand this topic and you want to go into deeper details, you definitely should look this up. So according to conclusion 8, the relevant practice must be general, meaning that it must be sufficiently widespread and representative as well as consistent. So it cannot be just any practice. Those practice must be widespread enough, representative enough, as well as consistent enough. Let's look at the example of the practices that has been recognized as customary international law. So first of all is the doctrine of non-refoulement, the granting of immunities for visiting head of states, Genoa Conventions, or Article 31 of the Vienna Conventions on the Law of Treaties that we have mentioned that even though the states are not the party of VCLT, you can also refer to this article as customary international law. So let's look at the past ruling where the court has given a little bit of definitions of customary international law. So in the North Sea Continental Shelf, 1969, let's read this together. For customary rule to exist, the acts concerned must not only amount to style practice, but they must also be such or be carried out in such a way as to be evident of the belief that this practice is rendered obligatory by existence of the rule of law requirement. This is the opinio juris aspect. The need for such a belief is the existence of subjective elements. It's implicit in the very notions of opinio juris The state concerned must therefore feel that they are conforming to what amount to legal obligations. So after you get the idea of what gives rights to customary international law, you understand that there are two main aspects that you have to consider, which is the state practice, and also the state practice must be considered as law, or the opinio juris aspect. So where do we find them? Where do we find the practices? So you can claim that certain argument that you're going to make has the status of the customary international law already. So first of all, I would like you to understand that the court has its own discretions to decide whether the practice that you bring up or mention had reached the status of customary international law or not, or is it considered as international law according to Article 38(1)(b). So your job as mooters is to convince the court that, for example, if it's your side that you want to claim that there are the customary international law, then you have to prove that there are enough practice that support your argument. Or if you're trying to claim or counter argument your opposing party that there isn't any customary international law, then you prove to the court that there are not enough practice, or even though there are practices, but those practices, they are not widespread enough, not accepted as law, or not consistent. It depends on your creativities. So, where do you find state practice? You can find it from diplomatic acts and correspondence, conduct in connection with resolutions adopted by international organizations or at intergovernmental conference, conduct in connection with treaties, executive conduct, including operational conduct on the ground, legislative and administrative act, and the decisions of the national court. As you can see, there are so many things that could be considered as practice, whether it could be decisions of national court, or it could be administrative acts. Are formal expressions of the will or opinion of the intergovernmental body, such as the United Nations, can also, which can serve to guide diplomatic act, declare positions on an issues, or even impose sanctions. That can also be considered as practice. So, if you want to find a practice, you can look at the UN Charter Conference, or you can look at the Sixth Committee Conference. You can look into the national court decisions. It depends on how you do your research, but I would say that the more practice you have, the more convincing you are to just persuade the court that it's whatever you're trying to claim has the status of customary international law already. So how about the opinio juris? Opinio juris, it's harder to prove because it is what is inside, so it's not tangible, right? But the ILC has listed the evidence of opinio juris in a non-exhaustive manner. So these four are just examples. It's not only limited to this, but let's look into it one by one. So first, public statement made on behalf of states, official publication, government legal opinions, diplomatic correspondence, decisions of national court, or the last one of this example, because as I say, it's not only limited to this, conduct in connection with resolutions adopted by international organizations or at an intergovernmental conference. So these four can reflect that the states has considered those practices as having legal obligations. let's look at the memory example so you will know how to lay down the research that you made on the practices. So this is 2025 GESF from the Philippine team, University of San Carlos, which is a very good example. If you want to write a good memorial, you can look into the best memorial of GESF year by year, and I think that would be very useful for you. So in this memorial, it states that immunity from foreign jurisdiction for states and their agent is established by state practice and opinion juris. So we now know that from now on, they will, from later on, they will lay down the research that they have made and the practices that they have found. And international custom codified in UN conventions on the jurisdictional immunities of the states and their properties. Many states like the United States, United Kingdom, Australia, Canada, and South Africa have enacted sovereign immunity law. So this is stated that these countries, United States, United Kingdom, Australia, has recognized these UN conventions on jurisdictional immunities of the states, and they have made it their national law. So this is the practice that you can find on the national law of these three. While domestic courts have consistently upheld the state immunities for acta juri imperii. So here you can see also in the footnote that they have cited the case, North Sea Continental Shelf, the national law of different countries. For example, here, Austria, United States, United Kingdom, Canada, Australia, South Africa. And this is just one form of practices that you can put in your memorial. You can also find the practices in the UN Conference on the Standing of Different States or Sixth Committee Conference. So now, after you understand the concept of Customary International Law or CIL, now you might wonder, how does this align with the principle of consent? Because you have learned that, for example, first source of international law, treaties, you have to open. The states has to sign and ratify that treaties to be a part of that treaties, which means they give consent to be bound by the obligations of those treaties. But how does this work for customary international law? Because you might understand that, if there are enough practices that are recognized as law, so therefore the customary international law is formed, and you nationally, as a state, bound by that customary international law. What you can do is to opt out, which means to free yourself from the obligations of that customary international law by being a persistent objector. So what does this mean? The definitions of the ILC DAP conclusions 15 to be precise, the persistent objectors, meaning that in the event that the state has objected a rule of customary international law while the rule was in the process of formation, the rule is not opposable to the state concerned for so long as it maintains its objections. So what does this mean? So it means that the states can be persistent objectors when that practice has not settled or has not reached the status of the customary international law yet. And how does the state do it? What does it mean to be a persistent objector? So according to these draft conclusions, the objection must be clearly expressed, made known to other states, and maintained persistently. So if you want to make an argument in your moot court competitions that you as a state is not bound by the customary international law, you are a persistent objector, then you have to be able to prove that your objection has clearly been expressed and made known to other states. For example, made known to your opposing party. And the present draft conclusion is without prejudice to any questions concerning peremptory norm of general international law or use cooking. This means that you can decide to opt out. You can decide to be a persistent objector as a state, as long as that CIL is not a peremptory norm. What does it mean, the peremptory norm? I will explain it to you later in the next slides. But for now, I'd like to note the relationship between the persistent objectors and the formations of CIL, which can be pretty confusing. So, the persistent objectors is to be distinguished from a situation where the objections of a significant number of the states to the emergence of a new rule of customary international law prevent its crystallization altogether. What does this mean is that you can imagine that if there are so many states that are the persistent objectors, that means that many states, they do not agree with the practices. So therefore, it could be the case that those practices are not settled and has formed the customary international law since the beginning. So there were no formations of customary international law because the objections of many states prevents it. So there were never a crystallization since the beginning. And I also would like to note that the CIL shouldn't be just a customary international law for international community as a whole. It can be in a smaller scale, for example, the original customary international law. So, according to the conclusion 16, a rule of particular customary international law, whether original, local, or other, is a rule of customary international law that apply only among a limited number of the states. Maybe you can imagine that there are a case that only a few states share the same geography. So, for example, some states are coastal states. So, of course, they are practiced only among the coastal states. That can also be called original customary international law. So, as I have mentioned, that the states can decide to opt out, to not be bound by customary international law, as long as that's customary international law is not a peremptory norm, or as we know it as jus cogens. So, what is peremptory norm? Peremptory norm is a norm accepted and recognized by the international communities as a whole that it is a norm from which no derogation is permitted and which can be modified only by a subsequent norm of a general international law having the same characters. So this means that peremptory norm can be modified if there are newer norm that's also a peremptory norm. So why does this cancel out the principle of consents? Peremptory norm is a norm that cannot be breached because, for example, it could be such grave and hideous crime that no nations or no states would accept that as slavery, for example. So to check if whether that is a peremptory norm or not, there are two criteria. So A, is it a norm of general international law? And B, it is accepted and recognized by international community of states as a whole, in which another derogation is permitted. For example, it could be slavery, tortures. So as a state, you cannot say that, okay, I decided to opt out, I will committed crimes of slavery because I'm privileged by the consents. That is not possible under the international communities. So, we have already talked about two subparagraphs already. So let's move on to the Article 38(1)(c). Still, there are no hierarchy between the three, remember? A, B, and C. This one called the general principles of law recognized by civilized nations. So you might have questions. What is civilized nations? I like to tell you that when this is written, the ICJ statutes, it has been long time ago. So that's what they called it back then, which might not be very politically correct for this present time that, as I have mentioned, that we have the belief that all the states are equal. There's no civilized nations, because every nation are civilized nations. What are the examples of the general principles of law? So it could be pacta sunt servanda, สัญญาต้องเป็นสัญญา good faith, and the principle of equities. So what are the purpose of the general principles of law? How do you use it? Because I have mentioned that even though the subparagraph 38(1)(a), (b), and (c), they are equal in natures, which means there are no hierarchy. But in practice, A and B, it's more used or accepted. So the general principles of law are mainly resorted to when other rules of international law do not resolve the particular issues in whole or in part, which means that there is no treaties or no customary international law that you could bring up to the court. So then this is when the general principle of law play a role. And second, general principles of law contributes to the core of the international legal system that may serve as to interpret it and to complement other rules of international law. Or B, as a basis for primary rights and obligations, as well as a basis for secondary and procedural rule. What does it mean that? It means that it has a gap closing measures. So a situation may arise when the court cannot find an applicable law to resolve the dispute at hand. In such instances, the court or the judge might look for relevant principles to close the gaps that might be uncovered in international law. Especially when, as I said, the treaty or the CIL are silent and cannot solve the problem. Where can we find a general principle of law? It can be divided into two categories. So first of all, it's derived from the national legal system. So you can find it in the different national legal system. Or B, it's maybe formed within the international legal system. These are the examples from the case factories at Chagall, Germany versus Poland that they point out that the principle is generally accepted by municipal courts. Municipal court here means the national court. And these are the example of the general principle of law that form within the international legal system. I'll move on to the next slide to give you a better explanations. So this is the identifications and determinations of the general principle of law, of how do we identify or determine it. So according to draft conclusion 4, identifications of general principle of law derived from national legal system. 2, determine the existence and contents of general principle of law derived from national legal system. It is necessary to ascertain these two aspects. So A, there's the existence of principle common to the various legal system of the world. So this principle, you can find it in many various legal systems of the world. And B, it is a principle that is transported to the international legal system. So it can also be applied in the context of the international legal system, not just the national legal system. And let's look at B, the second category, formed within the international legal system. So according to draft conclusion 7, these identifications of general principle, the definition is to determine the existence and contents of general principle of law that may be formed within the international legal system. It is necessary to ascertain that the communities of nations has recognized the principle as intrinsic to the international legal system. So the intrinsics here mean belonging to the essential natures or constitutions of a thing. So it has to be intrinsic to the international legal system. And the communities of nations has to recognize the principle. Let's look at the memorable example of proving principle of equities. So these will show how you utilize many different material, for example, the judicial decisions, the treaty itself, or the state practice, because we have learned how to apply them and how to bring them up to the court. So let's read this together. This is from 2025 JESA, Philippine teams again of the University of San Carlos. So it's written here that this court and other tribunals have consistently applied equities as general principle of international law. So we're trying to prove that there's the principle of equities as a general principle of international law. In the North Sea, continental shelf, and other cases, the court ruled that. So as you can see, they bring up the case, the North Sea, continental shelf, and other cases. And in the Bay of Bengal, the International Tribunal on the Law of the Sea held that. So now you're using the judicial decisions to prove that there's this principle. Let's move on. The UNCLOS itself includes many references to equities. Many states directly affected by the sea level rise, like Maldives, Antigua, and Barbuda, and refer to equities in determining maritime rights and boundaries. So this is when you mention the state practices from these different states, like Maldives, Barbuda, and this is how you utilize the state practices. We have gone over the 3 subparagraphs. Subparagraph A, B, and C, which we have learned that there are no hierarchy between them. So now moving on to the subsidiary meaning in the Article 38(1)D, which we learned that it has secondary natures. And it can be divided into 2 materials, which are the judicial decisions and the teachings of the highly qualified publicists. So first, we will begin with the judicial decisions. Does it have binding effect to the court? To answer these questions, we have to look at the Article 59 of the ICJ statute, which provide that as decisions of the court has no binding force except between the party and in respect of the particular case. It is a doctrine of precedent, which means that the court is not bound by a past ruling. Only the disputing party in that case is bound by the decisions. In realities, however, the court major decisions often have a huge impact, or we can call it a catalytic role, which means that they act like a powerful spark that speeds up or confirm the foundations of the new law. Especially in the case that the court is nearly unanimous and give a very strong reasons of a judgment. For example, in a famous early case like a reparations of the injury, the decision is treated by the world as a definitive statement of the law. In contrary, if the ruling is much criticized like Lotus decisions, the international community can sometimes simply ignore or reject that ruling later on. Despite these limits and possibilities of a judgment being rejected, other court and tribunals are rarely openly challenge the ICJ authority as it is a very well-respected court. So let's look at how we utilize the subsidiary mean, especially in the past ruling of the court. So these are the memory examples that will show you how do you utilize the relying or rejecting past ruling of the court. So in the Moot court competitions, there are situations that you found the past ruling of the court that support your standing. Therefore, you want to present to the court that the court should decide in the way that the court did in the past ruling. Or it could be the situation that you have done some research and you found some past ruling that it doesn't work in your favor, and you anticipated that the opposing party might bring up to the court and say that the court should decide in the same way as this ruling. So then you write the memorial in the rejecting way. So first, let's look at the relying first. So this is the 2024 Jessup Memorial from Canada, University of Toronto. So it's written here that this court in the Nuvong held that neutralization may not establish diplomatic protection if it is not based on any real prior connection, blah, 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 blah. So in this case, the memorial is trying to mention that this court has decided in its favor in the Nuvong case in the past, which is the case in the International Court of Justice, and also the exit also blah 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 blah. Exit is another court, another tribunal. It's not ICJ, but you can also apply it and utilize it to support your arguments. This is the situations that you are relying. So how to write the memorial in a way that you're trying to reject the past ruling? So this is an example from 2022, Jessup by Singapore team. It's written here that Antara cannot rely on these court decisions in the Nuvong case because the natures of the case is different. This is what they're trying to say. They're saying that in the Nuvong, it involved a German-born national residing in Guatemala, neutralized as blah, 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 blah. So what they're trying to do is that they're trying to point out the differences in the case at hand and the past ruling of the court. So what they're trying to do is to convince the court that the circumstances, the facts of the case are different. Therefore, the court should not decide in the way that they did in the past ruling, because it should not apply to this situation. So as you can see, just narratives, they just cite the case here, even though it's rejecting. They also cite the case and state the facts of the case that are differences. So now moving on to the second materials in the subsidiary mean in the Article 31B is the teachings of the most highly qualified hypothesis. So what is the teachings of the most highly qualified hypothesis? First of all, I'd like to mention that the teaching may take many forms, including digest, treatises, textbook, monograph, commentaries, journal, article, and blog post. But this cannot be just any digest, a monograph, or commentaries. You have to look at the writers or who publish it. So Ep01 turned from individual writer to the institution such as, which means that these are just examples, but it's not only limited to these institutions. I'm just giving you an example. So institutions such as Institut des Droits International or International Law Associations and expert group. The collective product of such learned body should be seen as a part of the teaching for the teachings of the most highly qualified hypothesis in this Article 38(1)(d). And I'd like to note very important thing, because throughout this whole slice we have mentioned many work from the ILC. So the International Law Commission, right, that we look at it for the clarifications of the treaties, the formations of customary international law, and you might understand that the status of the International Law Commission, or ILC, is also a teaching of the most highly qualified hypothesis. But I would like to note that many times the ILC article often used as a reflection of customary international law, and the ICJ has sometimes been ready to refer expressly or by implications to the certain ILC draft that it showed the practice that support that the CIL has already been formed. So to put it simply, it can also act as a proof that there are certain practice for certain customary international law. So that's it for the sources of the public international law. And if you have any question, please feel free to leave it in the comments, and we will reply and answer your questions. I hope that it could be beneficial and it could be useful for your moot court competitions. That's all for my part, and thank you so much.